Hello students, welcome to the lecture on photography and e-dimensions of intellectual property. And after this lecture, we will be able to learn the following objectives. Discuss the intellectual property rights. Define the copyright aspects about South Africa. Explain the obtaining copyright protection. Let's begin with the introduction to intellectual property rights. Copyright is a form of intellectual property. Intellectual property includes intangible assets such as works of authorship, ideas, and business goodwill. Intellectual property laws protect these intangible assets. Protection is secured through four separate bodies of law: patent law, trade secret law, trademark law, and copyright law. Patent law protects new, useful, and no obvious inventions. Trade secret law protects any formula, patent, practice, device, or compilation of information used in business that provides an advantage over competitors who do not know or use it. Trademark law protects words and symbols that are used in connection with products and services and are tangible representations of business goodwill associated with those products and services. Finally, copyright law protects the expressions contained in original works of authorship.
What's the difference between copyright, registered trademark, and trademark? We see these symbols many times a day, but what do they really mean? Let's start with trademark. This would be something that identifies your product or brand as yours. Suppose you were a methamphetamine maker and the tagline was, "It keeps you awake." You use it in your ads, then suddenly a coffee company starts using it. Well, clearly they are hitching a ride on your good rep. If that coffee company starts using it, then you would have to take them to court to defend it. But if that's not enough, you go to registered trademark. This just means you go to the government and register it. It's an extra protection. Since these are registered, they don't have to be maintained in the same way. So harder to get, but easier to keep. Okay, so what about copyright? This is pretty different. This is really the content of it all. So a song, a movie, a written work, these are all copyrightable. Thing is, everything is pretty much copyrighted to the creator, so I just like to put it there to be in your face. So now you can be a pedantic know-it-all to your friends. So that's our trademark. We should register it tomorrow and don't use this copyrighted video without it.
Let us now discuss intellectual property rights, IPR. Intellectual property rights are legal rights which result from intellectual activity in industrial, scientific, literary, and artistic fields. These rights safeguard creators and other producers of intellectual goods and services by granting them certain time-limited rights to control their use. Protected IP rights, like other property, can be a matter of trade, which can be owned, sold, or bought. These are intangible and no exhausted consumption.
Intellectual property rights are about more than just music and movies. They're in everything we do, make, use, eat, buy, and sell. Trademarks, geographical indications, patents, designs, and copyrights all support and promote our industry's economy, jobs, and innovation. IPR play an essential role in half of European businesses. And IPR support 1 in 3 jobs in the European Union. That's over 76 million jobs. IPR-intensive industries pay 40% more than other industries. Altogether, IPR-intensive industries contribute nearly 40% of the EU total GDP. That's 4.7 trillion euros. And that means more money for improving our communities. IPR-intensive industries account for 90% of the EU's trade with the rest of the world. IPR affect our daily lives in more ways than we can imagine. From creativity and innovation, to businesses small and large, to the economy in all member states. We all care about protecting intellectual property, and we can all contribute. Our everyday choices make a real difference.
Types and tools of IPRs: patents, trademarks, copyrights, and related rights. geographical indications, industrial designs, trade secrets, layout design for integrated circuits, protection of new plant variety. Patent. A patent is an exclusive right granted for an invention, which is a product or a process that provides a new way of doing something or offers a new technical solution to a problem. It provides protection for the invention to the owner of the patent. The protection is granted for a limited period, that is 20 years. Patent protection means that the invention cannot be commercially made, used, distributed or sold without the patent owner's consent. Trademarks. A trademark is a distinctive sign that identifies certain goods or services as those produced or provided by a specific person or enterprise. It may be one or a combination of words, letters and numerals. They may consist of drawings, symbols, three-dimensional signs such as the shape and packaging of goods, audible signs such as music or vocal sounds, fragrances or colors used as distinguishing features. Copyrights and related rights. Copyright is a legal term describing rights given to creators for their literary and artistic works. The kinds of works covered by copyright include literary works such as novels, poems, plays, reference works, newspapers and computer programs, databases, films, musical compositions, and choreography, artistic works such as paintings, drawings, photographs and sculpture, architecture and advertisements, maps and technical drawings. Geographical indications, GI. The GI are signs used on goods that have a specific geographical origin and possess qualities of a reputation that are due to that place of origin. Agricultural products typically have qualities that derive from their place of production and are influenced by specific local factors such as climate and soil. Industrial designs. Industrial designs refer to creative activity which result in the ornamental or formal appearance of a product, and design right refers to a novel or original design that is accorded to the proprietor of a validly registered design. Industrial designs are an element of intellectual property. Trade secrets. It may be confidential business information that provides an enterprise a competitive edge, may be considered a trade secret. Usually, these are manufacturing or industrial secrets and commercial secrets. These include sales methods, distribution methods, consumer profiles and advertising strategies, lists of suppliers and clients, and manufacturing processes. Layout design for integrated circuits. Semiconductor integrated circuit means a product having transistors and other circuitry elements which are inseparably formed on a semiconductor material or an insulating material or inside the semiconductor material and designed to perform an electronic circuitry function. The aim of the Semiconductor Integrated Circuits Layout Design SICLD Act 2000 is to provide protection of intellectual property right IPR in the area of semiconductor integrated circuit layout designs and for matters connected therewith or incidental thereto. Authorship and ownership of copyright. The author of a copyright work is generally the person who creates it. In relation to sound recordings, this is the producer. In films, the principal director and producer are joint authors. The author of a broadcast is the person who made it. Finally, the publisher of a typographical arrangement of a published edition is the author of it. Rights of copyright owner. There are two types: economic rights. The economic rights of a copyright owner are expressed in the Copyright Designs and Patents Act CDPA 1988 as a series of registered acts that only the copyright owner can do or authorize. These are to copy a work, to distribute copies of a work, to rent or lend a work, to perform, show or play a work in public, to communicate a work to the public which is any electronic transmission and includes broadcasting. Moral rights. The author of a copyright literary, dramatic, musical or artistic work and the principal director of a film have the following moral rights in relation to their work. Paternity right. The right to be identified as the author, such as having his name printed on his work. The right has to be asserted by the author in order to have effect. False attribution. A person has the right to not have a work which they have not created falsely attributed to him. Dealing with copyright. There are essentially two ways in which the copyright owner can deal with his copyright. Firstly, by assignment, and secondly, by licensing. Assignment copyright is a property right and therefore, like physical property, it can be assigned. Assignment is akin to selling all or part of the copyright. It is possible for the copyright owner to assign his copyright in its entirety to another party. Future assignment. The Copyright, Designs and Patents Act 1988 allows a copyright owner to agree to assign the copyright in works that he will create in the future. When such works come into existence, they will automatically transfer to the assignee in the agreement. Infringement of copyright. If a person carries out one of the restricted acts without the authorization of the copyright owner, this constitutes copyright infringement. These acts are strict liability, which means that it is not necessary for the copyright owner to demonstrate that the person conducting the acts knew that he was infringing copyright. Indeed, it is possible to infringe copyright subconsciously. Secondary liability. The Copyright, Designs and Patents Act 1988 provides that there are certain acts that constitute secondary infringement. These acts are either subsequent dealings with an infringing copy or an act which facilitated the infringement itself. The acts of secondary infringement are importing infringing copies, possessing or dealing with infringing copies, providing the means for making infringing copies, permitting the use of premises for an infringing performance, provision of apparatus for an infringing performance. Permitted acts. The Copyright, Designs and Patents Act 1988 allows a number of uses of copyright works without the permission of the copyright owner in certain specific circumstances. There are two distinct types of permitted acts: fair dealing and exceptions. Fair dealing. The fair dealing exceptions are fairly limited and exist for the purposes of non-commercial research and private study. Criticism and review, reporting current events, exceptions. There are also a number of general exceptions in the Copyright Act for a variety of purposes. Broadly, these are educational exceptions, exceptions in relation to specific acts taking place in teaching and educational establishments, library and archiving exceptions, it relating to various aspects of libraries and archiving, such as libraries make copies for use in non-commercial research or for archiving material. Incidental inclusion of the copyright work. This exception relates to the situation where, for example, a documentary is being filmed and incidentally includes a passing car playing copyright music or a building or sculpture which is a copyright work. Lawful use of a computer, program, database. A person who is lawfully using a computer program or database is allowed to make backup copies and in certain circumstances decompile programs. However, it must be noted this is only where the initial use is lawful. Time shifting. A limited exception is allowed so that a person in private and domestic circumstances can copy a broadcast and the copyright works embodied in it to watch or listen to at a more convenient time. Let us now discuss copyright aspects about South Africa. Copyright in South Africa, like in most other countries, differs from other forms of intellectual property in that it is not a right that needs to be registered. Unlike patents, trademarks or registered designs, copyright vests in the author of a work once the work is created in a material form. what is eligible for copyright protection. Through the years, certain classes of copyright have been developed, rather artificially, to describe works eligible for copyright protection. In general, any original work made by a qualified person is eligible for copyright protection. Originality refers to the fact that the author must have created the work through the application of the author's own creativity and labor. Author of copyright in terms of the South African Copyright Act. The authorship of copyrighted works is frequently disputed. The South African Copyright Act provides very clear guidelines as to who shall be considered authors of any particular types of copyrighted works. The summary of these guidelines: literary, musical or artistic works, the person who first makes or creates the work. Photographs, the person responsible for the composition of the photograph. Sound recordings, the person who made arrangements for the making of the recording. Films, the person who made arrangements for the making of the film. Broadcasts, the first broadcaster. Published editions, the publisher of the edition. Criminal offences, a number of acts conducted without the copyright owner's permission are classified as criminal offences. These are making an infringing article for sale or hire, importing an infringing article into the UK other than for private and domestic use, possessing an infringing article in the course of business with a view to committing any act infringing copyright, selling, letting for hire, offering, exposing for sale or hire, exhibiting in public or distributing an infringing article in the course of business. Benefits of copyright protection. Copyright protection provides a vital incentive for the creation of many intellectual works. Without copyright protection, it would be easy for others to exploit these works without paying any royalties or remuneration to the owner of the work. Copyright therefore encourages enterprise and creates a favorable climate to stimulate economic activity. Copyright protection provides benefits in the form of economic rights which entitle the creators to control use of their literary and artistic material in a number of ways, such as making copies, performing in public, broadcasting, use online, etc., and to obtain an appropriate economic reward. Creators can therefore be rewarded for their creativity and investment. Copyright Act copyright protection exists in original works of authorship fixed in a tangible medium of expression. The ease in which copyrights are secured under this definition has led to copyrights becoming the most widely available form of intellectual property protection. The discussion of the acquisition of copyright protection is divided into the following sections: originality requirement, works of authorship, fixation, automatic creation and compilations. Originality requirement. For a work to be protected by copyright law, it must be original. However, the amount of originality required is extremely small. The work cannot be a mere mechanical reproduction of a previous work, nor can the work consist of only a few words or a short phrase. Works of authorship. The Copyright Act uses the phrase works of authorship to describe the types of work that are protected by copyright law. This purposefully broadcast phrase was chosen by Congress to avoid the need to rewrite the Copyright Act every time a new medium was discovered. Fixation. In order for a work to be protectable, it must be fixed in a tangible medium of expression. A work is considered fixed when it is stored on some medium in which it can be perceived, reproduced, or otherwise communicated. For example, a song is considered fixed when it is written down on paper. The paper is the medium on which the song can be perceived, reproduced, and communicated. Automatic creation. The above three requirements are the only requirements for copyright protection. As a result, copyright protection exists the moment an original work of authorship becomes fixed. For example, the song in the previous example is protected by copyright at the moment it is written to paper or recorded on a cassette tape. A computer program is protected the exact moment it is saved to disk. No other actions are required for copyright protection. There is no need to learn application for copyright protection or to even place a copyright notice on a work. These additional steps, often referred to as formalities, were previously required to secure copyright protection. Under the current law, the formalities of registration and notice now merely serve as recommended steps to expand the protection provided by copyright. Compilation, copyrights, compilation. Copyrights are a special breed of copyrightable work. They are defined by the Copyright Act as a work that is formed by the collection and assembling of pre-existing materials or of data that are selected in such a way that the resulting work as a whole constitutes an original work of authorship. An example of a compilation would be a collection of the most influential plays of the 8th century. The individual plays themselves would not be subject to copyright protection since the copyright would have expired. Now in the end, let us summarize what we have learnt in this lecture. Protection is secured through 4 separate bodies of law: patent law, trade secret law, trademark law, and copyright law. Intellectual property rights are legal rights which result from intellectual activity in industrial, scientific, literary, and artistic fields. Industrial designs refer to creative activity which result in the ornamental or formal appearance of a product, and design right refers to a novel or original design that is accorded to the proprietor of a validity registered design. The economic rights of a copyright owner are expressed in the Copyright Designs and Patents Act CDPA 1988 as a series of registered acts that only the copyright owner can do or authorize. Copyright protection provides benefits in the form of economic rights which entitle the creators to control use of their literary and artistic material in a number of ways, such as making copies, performing in public, and broadcasting, use online, etc.